rise for your honour Howarth.
At the very outset, you are, the jury, going to be concerned in this matter by death caused by a fall from height. In fact, a height of 24 feet. This is the distance that Thomas More fell onto a concrete floor. He landed directly on his head, sustaining a massive injury. Falls from height are the most common cause of fatal accidents in the workplace in the United Kingdom. Mr. More's accident and tragic death was not a one-off. In the construction industry, it is well known that there are considerable risks faced by those working at height, and that therefore proper and effective steps should be taken to prevent people from falling a distance likely to cause death or injury. Wallace Limited employed Seymour Limited to provide a program of planned preventative maintenance. Seymour Limited had been asked to come to the Wallace Limited site in Essex to investigate and repair a leak from a roof into a building being used for storage. Thomas More was asked by William Hastings, Seymour Limited's contract manager, to carry out an investigation into the leak and effect repairs. He told Mr. More that the flat roof was safe to walk on. On 7th of April, Thomas More climbed out of the window of one of the offices in the adjacent building onto the flat roof and walked around to see if he could locate the source of the leak. As he was walking on the roof, he stood on a glass skylight. This cracked under his weight, and he fell to the floor, sustaining fatal injuries. The investigation found that there was no edge protection around the open edges of the flat roof of the building where Mr. More fell. The skylight was covered in dirt and mud and was unprotected. It became clear that Mr. Hastings had never been out onto the flat roof, as he had told Mr. More. The roof had never been inspected. Thomas More had not received any training to work from height. He had been with Seymour Limited for 6 months and had received basic induction training on health and safety. Seymour Limited did not provide a safety harness or any safety equipment to Mr. More to carry out the task, although harnesses were available. An assessment had not been carried out in respect of the strength and integrity of the roof, or any attempt made to locate the fragile parts of said roof. Any paper inspection would have identified the skylight through which Mr. More fell. Seymour Limited, the first defendant, faces an allegation that it unlawfully killed Thomas More. It is brought under new legislation called the Corporate Manslaughter and Corporate Homicide Act. Seymour Limited is also charged with a breach of Section 2, Paragraph 1 of the Health and Safety at Work Act 1974. Mr. Hastings, the contracts manager of Seymour Limited, was interviewed. It was his responsibility to attend the premises when the contracts were first taken out, and to carry out an assessment of the property and produce risk assessments or method statements. His manager was the operations director of Seymour Limited, Mr. John Devereux. Mr. Hastings gave evidence in interview that there was a shortage of experienced and trained staff capable of carrying out site-specific risk assessments and producing method statements. There were insufficient experienced people to provide supervision that he would have liked. He also gave evidence that many of the operatives working at height had not been properly trained. John Devereux, the operations director of Seymour Limited, was interviewed under caution. He stated, in interview, that the company operated under a very strict budget and staffing costs were very tightly controlled. He accepted that on some occasions junior staff who had not received training were instructed to carry out work at height on what he described as straightforward tasks, such as clearing gutters. Mr. Devereux went on to say that the company had a strategy to expand as quickly as possible. He admitted that the company saw this as a number one priority, and health and safety was often overlooked. He accepted that he had day-to-day management of the contracts and that he was responsible for the health and safety issues that arose. The company knew that site-specific risk assessments were not being carried out, and that safe systems for carrying out work were not being produced. The generic risk assessment had not been distributed to any of the staff. The company was also well aware that untrained operatives were carrying out work at height, and were aware that there were insufficient numbers of trained people to provide supervision and training. Mr. Devereux had ultimate responsibility for this. A significant element of the breach was at senior management level, and their breach was a gross breach of that duty, resulting in Mr. Moore's death. The second defendant, Wallace Limited, are charged with a breach of Section 3, Paragraph 1 of the Health and Safety at Work Act, 1974. Section 3, Paragraph 1 of the Act states that it shall be the duty of every employer to conduct his undertaking in such a way to ensure, insofar as reasonably practicable, that persons not in his employment are not exposed to risks to their health and safety. The third defendant, Mr. Devereux, faces two offences. He faces an allegation that he unlawfully killed Thomas Moore. He also faces an offence contrary to Section 37 of the Health and Safety at Work Act, 1974. On the evidence you will hear, the prosecution maintain that you'll be satisfied beyond reasonable doubt that all of the defendants are guilty of the offences with which they are charged. Accordingly, proper verdicts in this case are ones of guilty. Now I'd like to call William Hastings to give evidence for the prosecution.
Please state your name.
William Hastings.
Now, Mr. Hastings, is it right it was your responsibility to put together this initial report for the Chelmsford Depot?
Unfortunately, I didn't get time to complete the report as I would have liked. I didn't get time to consider all the safety implications for the site.
And why was this?
I should have had help from others qualified to complete risk assessments, but there were just insufficient numbers of people around.
And did you ask for any assistance?
Yes, I did on many occasions. I spoke to Mr. Devereux on a daily basis. He was aware of the problems.
I would like to show the jury Exhibit WH1, which is an email sent by Mr. Hastings to Mr. Devereux on the 6th of March 2008. Email reads, John, I am afraid we are getting towards breaking point. I have not got enough experienced operative to carry out the routine maintenance work and repair works. Unfortunately, I am being stretched and do not have time to carry out all the task-specific risk assessments. Obviously, we have some older generic risk assessments we can use for some tasks, but I cannot arrange for site-specific and job-specific risk assessments to be done before the repair works are carried out. This is an accident waiting to happen. Why didn't you undertake the risk assessments yourself?
I did as many as I could, but I just had to make sure that the initial assessments on the new contracts were carried out first.
And you say there were insufficient numbers of trained staff?
Yes, that's correct. Many left due to the working environment they were asked to work in.
Did Wallace Limited ever ask to see a risk assessment or method statement?
On some occasions they would, but not for any urgent repairs. They just told us to get on with it.
Thank you, Mr. Hastings. I have no further questions. And now I'd like to call Tom Jones to give evidence for the prosecution.
Please state your name.
Tom Jones.
Yeah, on the date of the accident, 7th of April 2008, you were employed by Seymour Limited. Can you tell the court your role?
Yes, I was a maintenance operative. It was my job to attend premises on behalf of Seymour Limited and carry out maintenance and repairs.
And what instructions would you receive?
Well, usually it was to carry out inspections and maintenance at premises. I'd be given initial maintenance assessments together with a number of risk assessments and safe operating procedures to go with it.
And what about repairs? What instructions did you receive?
Well, again, I'd be given specific instructions on what repairs needed to be carried out. And sometimes there'd be risk assessments and method statements.
Did this always happen?
Unfortunately, I didn't always get risk assessments. Mr. Hastings would often phone me and ask me to attend a particular depot or building and carry out specific repairs. It was all a big rush.
Have you had any training for working at height?
No, I was due to get some training, but this just didn't happen.
Thank you. No further questions.
On behalf of the defence, I would like to call Mr. Devereux to the stand.
Please state your name.
John Devereux.
At the time of the accident, you were Operations Director for Seymour Limited. Is this correct?
Yes, that's correct.
What was Mr. William Hastings' role?
He, with his team of skilled operatives, would firstly produce a health and safety assessment of the depot. This would include an overview of the operations carried out at that property and a maintenance schedule and an immediate repairs schedule.
Turning now to the accident involving Mr. Moore on the 7th of April 2008. What did you know of this particular job?
Nothing really. Bill Hastings gave me a call, told me he was a bit pushed to get someone to Wallace's Colchester depot. So I told him to send whoever was available and get it checked out.
You felt that there were sufficient numbers of operatives available to go and do this work?
Yes, I didn't see any problem.
Thank you very much, Mr. Devereux. Please wait there. There will be some further questions.
It is true, isn't it, Mr. Hastings told you he did not have any experienced people to do this job in Colchester?
Well, yes, it's true, but that's just him. I knew that Thomas Moore had just finished a job, so we could send him.
But Mr. Hastings was unhappy with this. He told you Thomas Moore was not experienced enough to do the job on his own.
Yes, well, he's always unhappy. It's always more resources, more trained men, more time needed.
Did he not tell you he was concerned a risk assessment had not been carried out for the task?
I thought Bill Hastings would have copies of these. I thought he could use those.
Yes, but they were very general risk assessments and they didn't relate to this specific job of going onto this roof at this depot.
Oh, I don't really see the difference.
Why didn't you take on more experienced staff to help?
We had to keep costs down, offer a decent price to our prospective clients.
Mr. Devereux, it's true to say, isn't it, that you put the profitability of the company before the safety of your employees. You ignored the requests and appeals of Mr. Hastings, your operations manager, who you accept knew far more about health and safety than you did. You paid lip service to the health and safety of your employees. This was an accident waiting to happen.
I just wanted to ensure that Seymour's would grow in accordance with our 5-year plan. I felt we could introduce safety measures once we'd expanded and could afford to put all of those measures in place.
No further questions.
Members of the jury, have you elected a foreman?
Yes.
Have you come to a decision?
Yes.
Count 1, Seymour Limited. What is your verdict?
Guilty.
Count 2, Seymour Limited. What is your verdict?
Guilty.
Count 4, John Devereux. What is your verdict?
Guilty.
Seymour Limited has been found guilty of the offence of corporate manslaughter. Seymour Limited has also been found guilty of an offence under Section 2 of the Health and Safety at Work Act 1974. Wallace Limited pleaded guilty to the offence under Section 3 of the Health and Safety at Work Act. John Devereux has been found guilty of gross negligence, manslaughter and Section 37 of the Health and Safety at Work Act 1974. The company was stretched in its race for growth, and insufficient resources had been allowed to carry out work safely at a number of sites where the company carried out maintenance work. Mr. Hastings had asked for help on a number of occasions, and this had either been forgotten or deliberately ignored. The primary concern for the organisation was to grow as quickly as possible, to take on as much work as possible, to try and manage that work with limited resources. At best, health and safety took a back seat. At worst, was ignored. No proper consideration was given to the safety of its employees. A culture existed of putting profit before safety. The failure of Seymour Limited was very serious indeed. I fine Seymour Limited the sum of £3 million, and I fine Wallace Limited the sum of £500,000. The said fines are to be paid within 1 year. I now turn to you, Mr. Devereux. I've decided that the offence you have been convicted of is so serious, I have no alternative but to impose an immediate custodial sentence. I therefore sentence you to 18 months' imprisonment. I hope you will reflect on the failings I have outlined and on the tragic results of those failings. Take him down, Warden.